Welcome back to The Explainer. Today, we're jumping straight into the incredibly complex and, frankly, high-stakes world of child custody here in Georgia. When a family fractures and parents just cannot agree on who gets custody, the court has to step in. But judges can't exactly leave their benches to go see what's actually happening inside a family's home, right? So they appoint a proxy, a guardian ad litem, or GAL. We're going to dive deep into this today because truly understanding this role is absolutely crucial for anyone navigating the family court system. An investigative report by 11 Alive perfectly set the stage for our discussion today with this quote. Literally, they have a lot of power with little to no regulation. In a private domestic custody dispute, the guardian ad litem becomes the eyes and ears of the court, and their recommendations, they can completely alter the trajectory of a family's life. But how exactly do they operate? And maybe more importantly, what happens when parents feel like this immense power is going totally unchecked?
Okay, here's our game plan for today. First, the paradigm of power. Second, inside the investigation. Then we'll cover courtroom rules and hearsay, the accountability void, strategies for parents, and finally, the horizon of reform.
All right, let's get into part one, the paradigm of power. So in private domestic cases, Georgia law completely tosses out any automatic preference for the mother or the father. Instead, the whole case revolves around what's called the best interest standard. The GAL acts as an independent investigator, an actual officer of the court, whose sole job is to evaluate some very specific factors. They're looking closely at emotional ties, parental capacity for basic care, the kid's daily routine, home stability, and of course, safety from abuse. They aren't there to figure out which parent is nicer, they're trying to figure out which environment is going to allow the child to thrive.
Now, this creates a pretty massive legal paradox. Think about it. A traditional attorney advocates for exactly what their client wants. But a guardian ad litem? They advocate for what's best for the child, even if the child strongly disagrees with it. In fact, if an attorney is serving a dual role as both the kid's lawyer and their GAL, and the child's wishes conflict with their actual safety and well-being, state ethics rules obligate that professional to step down from the GAL role. They're not just a mouthpiece for the kid, they are an objective evaluator for the judge.
Moving on to part two, inside the investigation.
Once they're appointed, a GAL kicks off what is honestly a deeply intrusive three-step process. First up, document review. Parents are routinely forced to sign blanket HIPAA waivers. This allows the GAL to bypass normal privacy laws and pull medical, psychological, and school records. Next, home visits, and these can be completely unannounced, which lets the GAL observe organic, unfiltered interactions between the parent and child in their own environment. Finally, child interviews. This is super critical in Georgia for kids 14 or older because they have a statutory right to choose which parent they want to live with. The GAL has to vet this choice thoroughly, just to make sure it's not the result of coercion or parental alienation.
Next up, part three, courtroom rules and hearsay. By its very nature, a GAL's report is essentially a giant compilation of things other people said, right? Teachers, doctors, neighbors. In legal terms, that's hearsay, which normally gets totally blocked from a trial. But there is a huge loophole here, the explanatory conduct workaround. Skilled attorneys will argue that these out-of-court statements aren't actually being submitted to prove they're objectively true, but rather to explain the methodology of the GAL. It tells the judge why the GAL made their specific recommendation, which basically lets all that hearsay sneak in right through the back door.
There's also another critical tool at play, known as the child hearsay exception. Under Georgia Code, statements made by a kid under 16 describing acts of physical or sexual abuse can actually be admitted into evidence through the GAL's testimony. Now, there are strict rules. You have to give advance notice, and the GAL must be subject to cross-examination. But it's an incredibly powerful way to protect vulnerable kids from having to testify in open court while still getting the facts right in front of the judge.
Which brings us to part four, the accountability void.
This system creates a glaring systemic anomaly. If an attorney messes up, they answer to the state bar. A doctor answers to the medical board. Even a court mediator answers to a state office. But a guardian ad litem? There is literally no statewide regulatory agency, no central oversight board, at all. If a parent has a legitimate grievance about bias or a totally botched investigation, their only real recourse is to complain to the exact same judge who appointed the GAL in the first place.
Because there's no state oversight, broad local authority falls squarely on individual superior court judges. Investigative journalism, like those reports from 11 Alive, has really highlighted the vulnerability this creates.
We've seen reports from parents, people like Tatiana Ellis, Ryan Bondell, and Robbie Roberson, who felt totally financially trapped by massive GAL fees that sometimes ran into the tens of thousands of dollars. And when they pushed back or tried to get the GAL removed, they reported facing judges who threatened them with contempt of court or even jail time if they didn't pay up.
And the stakes go far beyond just money. Investigations have shined a light on this heartbreaking phenomenon known as trading custody for care. In cases involving kids with severe autism or extreme behavioral challenges, like a 14-year-old boy named Bradley featured in recent reports, parents sometimes feel forced to surrender custody of their own child to the state just to get access to residential treatment facilities. And shockingly, some GALs have subsequently argued against reunifying the family, classifying that desperate search for medical help as parental abandonment.
Let's pivot now to Part 5, Strategies for Parents.
If a parent really feels the GAL is biased, Georgia court rules do allow for a motion to remove them. But keep this in mind, you have to prove good cause, and that is an exceptionally high burden. Just disagreeing with the GAL's opinion is absolutely not going to work. To actually succeed, you need concrete, undeniable evidence of severe violations. We're talking undisclosed financial conflicts of interest, gross negligence where they completely failed to do their job, or demonstrable, written evidence of explicit bias.
And that leads us to this essential strategy. Proactive management is vastly superior to reactive removal. Directly attacking a GAL's personal character in court is almost always a terrible idea. It usually just alienates the judge who appointed them. Instead, successful litigants carefully manage the GAL's methodology throughout the investigation. Don't fight their personality. Instead, prepare precise clinical cross-examinations that expose the actual gaps in their factual research.
Finally, Part 6, the horizon of reform.
So the push for change is coming from two distinct directions right now. On one side, you've got consumer-led grassroots advocacy. Groups like the Georgia Parent Accountability Coalition, or GPAC, are demanding strict liability and independent statewide oversight boards so complaints aren't just routed right back to the appointing judges. On the other side, you have professional internal reform. Veteran attorneys have formed groups like Georgia GALs to push for rigorous, voluntary best practices and advanced education. The big debate right now is whether voluntary professionalization is enough or if state-mandated accountability is actually required.
We're also seeing a real climate of legislative momentum. Now, while our focus today is on private domestic cases, it's definitely worth noting recent laws like Senate Bill 376, passed in 2024 for state dependency cases. This law empowers an attorney ad litem to proactively petition to terminate parental rights if state agencies are dragging their feet. It's a perfect illustration of how lawmakers are actively expanding and redefining the powers of child advocates across the entire judicial spectrum.
Let's look at a massive cultural shift on the horizon too and see how this builds on a gal's investigative duties. It's called the Grayson's Law movement. This seeks to expand the legal definition of domestic violence to include non-physical coercive control, stuff like financial manipulation, isolating a partner, or psychological abuse. If this gets fully adopted in Georgia, it's going to force gals to broaden their investigations far beyond just physical safety. They'll need a much more sophisticated understanding of family psychology.
In the absence of a statewide fix, some local circuits are just taking matters into their own hands. The Blue Ridge Judicial Circuit, up in Cherokee County, is a prime example of this. They manage their high volumes of family law cases through strict local panel guidelines. They require mandatory continuing legal education specific to family court, and they actually make parents attend a family law workshop to preemptively reduce conflict before a GAL is even assigned. It's a localized band-aid for sure, but an effective one.
Which brings us to our final thought for today. Gals are basically asked to do the impossible, distill decades of messy, emotional family history into a neat little legal recommendation. But as family dynamics evolve, as the definitions of abuse expand, and as the stakes for parents remain as incredibly high as losing their own children, we have to ask, who guards the guardians? Finding that delicate balance between judicial efficiency and family protection is definitely the next great challenge for Georgia's courts. I really hope this gave you a solid grasp of the system. Keep learning, and we'll catch you in the next explainer.